Hi guys, Reverend Crystal Cox here. This is part 3. The video shut off and who knows where. I kind of have an idea, but so here's the deal. It shut off in the part that cracks me up, which is Mark Randazza thinking that he has a right to solitude and seclusion. Okay, but I don't have that right. He puts my home address on the docket. His buddies text me, they're coming to my town. I get threats constantly. I'm under constant duress. He has violated my rights to privacy. He defended Kate Gosselin, right? And she has a right to privacy in her emails, but I don't. He gets my emails. He gets information from my church. He gets information from my friends, my family. He bullies people. He threatens people. He's just relentless. And then because I bought a domain name, I have violated his... I have intruded on his rights to seclusion. Intrusion of seclusion. Really? He interfered with my $10 million case. He advised the plaintiff in that case to steal my right to appeal through a sheriff's sale. When I had a $2.5 million judgment, which has since been overturned. I still have to face that $10 million lawsuit in the lower court. He has made me publicly look like a criminal and extortionist, which has prejudiced me in my lower court proceeding when I go back to be pro se, representing myself in Obsidian versus Cox. He has threatened my sources. He has sued my sources. He's put makes in my car and wished death on my sources. He's just been relentlessly attacking me. He has caused irreparable harm on my health, on my life, my relationships, my relationship with those I spiritually counsel. Just massive, massive damage relentlessly since November of 2012. Well, actually, that was when he filed this lawsuit. He actually started harassing me right around about, let's see, December of 2011, he was acting as my attorney. So that next January 2012, he's been harassing me and attempting to sabotage me ever since then. Okay? But yet he tells the courts that I have interfered on his right to seclusion. I have intrusion upon seclusion. Okay, so number 5, genuine issues of material fact preclude summary judgment on Claims 8 for common law intrusion upon seclusion. The Randazza's 8th claim alleges that defendants' registration of 5 of the domain names containing the entirety or part of their names amounted to a common law intrusion upon seclusion. To recover for the tort of intrusion, a plaintiff must prove that there was an intentional intrusion, physical or otherwise, on his seclusion that would be highly offensive to a reasonable person. Uh-oh. There's the problem, folks. A reasonable person. We just don't have a reasonable person at Randazza Legal Group. I mean, they completely... Did you hear Randazza on NPR? Just like throwing a big hissy fit and crying because I bought a domain name. And NPR guy, Bob Garfield's like, what was your darkest hour of terror? I mean, I thought I was watching like some sort of a parody on the legal system. I mean, what a joke. But it's not a joke that they've used it to ruin my life, to suppress my speech, to take my blogs, to put it in Forbes, NPR, WIPO, Fraud Files with Tracy Conan, New York Times. It's not a joke when this ruins people's lives. It shuts people up. It gets them lawsuits against them where they have to pay these attorneys to harass them like this. Most people that are sued by these folks give up long before I did. And that's because they have kids, or they have, regular mainstream jobs, or they have, they're threatened with jail or mental institutes or things that they can't stay in the fight as long as I have. And so it's not okay for Mark Randazza to have done what he's done. To use the legal system, to use legal blogs of his friends and buddies to create some sort of what it looks like his target is a criminal, then gives this information to the judges and says, see, there it is, she's a bona fide criminal, right there it is, says so. And his buddies have said it, and Forbes have said it, and all of these are supposed to be credible. Well, this judge is saying no. Forbes is hearsay, the New York Times is hearsay, NPR is hearsay. Okay? Yet you have the judges, the Ninth Circuit judges in my case, that say that it's not, they won't even listen to the issue. They're just like, They call me a criminal. That's okay, right? Because their life is more important than mine. Okay? They can just say whatever they want and take a pot shot at me and just to keep me down, keep me suppressed because I'm exposing corruption. It's not right and it's not legal. Okay, so to recover for the tort of intrusion, a plaintiff must prove that there was an intentional intrusion, physical or otherwise, on his seclusion that would be highly offensive to a reasonable person. To have an insert in seclusion or solitude, to have an interest in seclusion or solitude, which the law will protect, a plaintiff must show that he or she had an actual expectation of seclusion or solitude, and that the expectation was objectively reasonable. Generally, there is a decreased expectation of privacy in the workplace and for individuals who have interjected themselves into the public sphere. You know, like you, Mark Randazza. Media whore. Allegedly, of course. Genuine issues of material fact preclude entry of judgments in plaintiff's favor on this intrusion claim. Plaintiffs Jennifer and Natalia have failed to show by admissible evidence that the mere registration of a domain name would be highly offensive to a reasonable person. There we have it. The Randazzas are unreasonable people. Now we know. Okay, failed to show by admissible evidence that the mere registration of a domain name, which apparently is huge news to Forbes and the New York Times and, you know, Tracy Conan and NPR, it's just huge, massive. We have a porn attorney here who supports someone who writes a guide to being a pedophile, who goes to things with the Free Speech Coalition with, I mean, known pedophiles, registered pedophiles. He defends those that are involved in human trafficking. He's a porn attorney. And these guys are all attacking me for buying a domain name? Alrighty then. Okay. So, I'll read that again. Have failed to show by admissible evidence that the mere registration of a domain name would be highly offensive to a reasonable person. And Mr. Randazza has failed to show that registering the domain names, coupled with the comments contained in the 2 admissible blog posts, would be highly offensive to the reasonable person as a matter of law. Aww, was the unreasonable Mark Randazza offended? I'm so sorry. Mr. Randazza says that the solution to bad speech is more speech. Well, I think Crystal Cox has proved him wrong because I've given him all kinds of more speech, more speech, more speech. And all he's done is take it to the docket because he's too damn dumb to get higher in the search engines than me, right? So he has to steal my search engine rankings, steal my domain names, accuse me of extortion, publicly defame me in WIPO, defame me in NPR and everywhere else he can, and lie under oath to the Ninth Circuit to make me look even worse. And all this, and he was my attorney. I mean, I don't know that it gets much worse than this, folks. All right, Mr. Randazza has a decreased expectation of privacy in his workplace. By his own characterization, he is an attorney renowned throughout the United States and the world for expertise in First Amendment intellectual property and internet law. He authors a blog about various legal issues, and the blog is an ABA-recognized top blog website. On his blog, he goes to great length to explain why he has the audacity to believe that he is qualified to teach others a thing or two. He has the audacity to believe that he is qualified to teach a thing or two to the others. Sorry, I had to read that again. I think it's kind of funny. Okay, he touts himself as having experience and expertise in all areas of First Amendment and entertainment law matters. I don't think so. He boasts about getting to fight the good fight, protecting all our First Amendment freedoms. Well, not mine. And openly proclaims that he has represented adult entertainment establishments against socially conservative communities. By talking about his experiences and the clients he represents, Mr. Randazza invites commentary on his work as an attorney and criticism from those who oppose the position of his clients. Mr. Randazza may be perceived to have interjected himself into the public sphere by making television and radio guest appearances, giving quotes in interviews in newspapers, magazines, and other publications, appearing at speaking engagements, and having an ABA-recognized top blog website, all as reflected on his resume. Considering his intentional and deliberate professional exposure and interjection into the public sphere and the accompanying decrease in his privacy interest, he has not demonstrated as a matter of law that he had an actual or reasonable expectation that he would not be criticized based on his work as an attorney, or that he would not be thought about unfavorably by people in opposition to his work. So we've called out the truth now. He was butthurt, even though he said Sandra Fluke cannot sue Rush Limbaugh, blah, 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 because she can't sue over being butthurt. But he sued me because he was butthurt. And what was he going to win? He knew I didn't have any money, right? He was my attorney, for crying out loud. He sued me to make a point and to set a precedent so that he can do this to other people who do have money. Okay, yeah, and he says that everybody is allowed to free speech, and even if you don't like the speech. I mean, he defends free speech every which way, but his ego got so out of control with me that he suppressed my free speech rights, sued me, and he went completely opposite of everything that he allegedly stood for. I mean, where does the guy go from this? I'm not really sure. As the Randazzas have failed to establish essential elements of this claim, summary judgment in their favor is simply not available. Well, 5 down. Number 6. Genuine issues of material fact preclude summary judgment on Claim 9 for civil conspiracy. Plaintiff's 9th claim alleges that Bernstein and Cox colluded to register the domain names containing the entirety or part of the Randazzas' names to violate their rights. Yes, that's exactly what I did. I registered the domain names to violate Mr. White Knight, asshole, hypocrite, porn attorney Mark Randazza, who violated my rights and continues to every single day. And who knows how many others he's done the same thing to. Because they didn't squeal as loud as me. Kind of a loud mouth. I don't know if you knew that or not. To state a valid claim for civil conspiracy, a plaintiff must show 1. Defendants by acting in concert intended to accomplish an unlawful objective for the purpose of harming the plaintiff. And number 2, the plaintiff sustained damage as a result. A civil conspiracy claim operates to extend beyond the active wrongdoer liability in tort to actors who have merely assisted, encouraged, or planned the wrongdoer's acts. Genuine issues of material fact also preclude entry of judgment in the Randazza's favor on this theory. They have not demonstrated by admissible evidence that Cox and Bernstein acted in concert. The only admissible evidence on this point is a blog post purportedly written by Cox. Plaintiff claims that Cox states that Bernstein is her business partner, which is flat out false. He just says what he wants and sometimes even swears to it. However, the pro-offered evidence does not compel that conclusion. The blog post refers in different places to the website markrandazza.me that Bernstein is a co-defendant in this case and that Cox and her business partner have been customers of GoDaddy, Inc. for several years. The blog does not, as plaintiffs suggest, identify or definitely reflect that Elliot Bernstein is the business partner Cox is referring to in the post. And he certainly is not. I've never been in business with Elliot Bernstein. Okay? I've written on his story for 4 years, which is amazing. iViewit.tv. iViewit company invented everything to do with video technology, and the inventors never got any rights. It's a $13 trillion technology. And who makes the most money off of it? Probably the porn industry. Defendant Cox is not entitled to summary judgment on her claims either. Cox moved for summary judgment on her original countercomplaint, and that countercomplaint has been stricken, and Cox was given leave to refile an amended counterclaim, so this is mute and denied. Okay, and then it just goes on to a few other things. So basically, I wanted you folks to know that right to publicity in Nevada law, and to realize that you know, at least there's one judge out there that does recognize the fact that you can't use hearsay as admissible evidence that's authenticated, okay? If, I guess maybe, and I'm just speculating here, if the New York Times or the Forbes, you know, like if say Kashmir Hill had give a sworn document that she could attest to this is 100% true, and, you know, somehow then maybe it could be authenticated. I'm not sure. But it is wrong. It's wrong for the New York Times and Forbes NPR to be used as evidence in your court case. Now, attorneys like Mark Randazza just use it to create a, you know, the ganging up effect. And they affect the judges. And because they're valued by judges more than people who are pro se, the judges tend to believe them. Like Marco Hernandez, you know, David Amen was constantly trying to tell him that I was extorting him. I never extorted David Amen. I mean, I sent an email, a settlement offer, after I'd been sued for $10 million, and there was 5 emails explaining what it meant. He took a part of one, and the jury convicted me, and this email went around the world, and I've been labeled as an extortionist for years now. And I was never given due process on any of this. And so there is a really good record as to defamation lawsuits and harassment against Forbes, New York Times, Reuters, Randazza Legal Group. There's a whole bunch of people that have wronged me in PR, and if any attorney wants to represent me in these matters on contingency, then I would love that. My email is crystal@crystalcox.com, and I hope you guys enjoyed this. I know it was really long-winded, but it's important stuff. Randazza versus Cox, you can go to archive.org and you can search Randazza versus Cox and you can get the whole docket, or just search Randazza Legal Group Crystal Cox docket, or you can email me if you need any documents in this case. Study all the documents of this case. Understand the hypocritical actions of Mark Randazza. What I really enjoy doing, kind of one of my hobbies, is getting, you know, where he's fought the other side and taking his own words and using them in motions. You know, because he's fought both sides, and that's what attorneys do, right? You're hired, so you just pick a side. Well, that's all fine and dandy until you are the plaintiff in one of the cases. You know, anyway, I'll let you guys know what happens next, but it seems to me that in this ruling, he doesn't have anything to stand on as evidence to move towards a trial with me. Okay, he can't have summary judgment. I am still my own attorney. I've been trying to get the courts to appoint me an attorney because I'm under an enormous amount of stress and I can't take it, and I don't know the laws. I don't know the rules of procedures. I'm a creative writer. I've been doing the best I can because I want to make a stand for others like me. So I don't want to just let it go away because I want to get enough on the docket that helps others in the future. The whole point of putting everything on the docket that I have is to help the whistleblowers, help other citizen journalists, other bloggers, other people that are trying to report on what's going on in the porn industry. Because some of these people are driven to suicide, they're killed, they have heart attacks, they have, they're just put under massive duress, they're sued, they're threatened, their families are threatened, all because they've stood up to these guys in the porn industry. Well, now you have blogs. And blogs are the new media, and they're the only way that people exposing corruption really have to expose it. And now you have an equal right in a higher court to do so. And so we can't have the courts at the same time allowing regular, you know, mainstream journalists to paint you out as a criminal, or lawyers like this to pile up evidence of their buddies and their different media and lawyer connections to make it look like you're a criminal. There's important, dark, sick issues in the porn industry that people like Desi Fox and Monica Foster are exposing, and it's very, very important. They're like two very prominent investigative bloggers in that industry that are exposing corruption. And the human trafficking, the organized crime, the pedophiles, the Free Speech Coalition, what goes on in the porn industry needs to be exposed. And there's a lot of layers to it. I've written a lot about it. I've learned a lot about it, and I was going to go into some of the stories, but I think that's enough for today. I hope you all have a great day, and God bless you all.